The Honorable, the Supreme Court.
Good morning, everybody. Thanks very much. Please be seated. And when you're ready, call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In re Rutland Regional Medical Center, fiscal year 2025, case number 24 AP 325. Representing the appellant, Rutland Regional Medical Center, is John Serafino. Seated at counsel table with John Serafino is Elizabeth Glynn and Mitchell Baruti. Representing the appellee, Green Mountain Care Board, is Ryan Kane. Seated at counsel table with Ryan Kane is John Rose.
Thank you very much. Good morning, counsel. We'll hear from counsel for the appellant first, of course. Please come on up. And for the record, introduce yourself and identify your client.
Morning, Your Honors. My name is John Serafino. I represent the Rutland Hospital, Inc., which does business as Rutland Regional Medical Center.
Thank you.
May it please the court, Rutland Regional Medical Center exists to provide high-quality, affordable health care to respond to increasing patient demand. And in the process of seeking approval for its fiscal year 2025 budget, it proposed an increase in net patient revenue of 6.1% over the previous fiscal year. The board, through hearings last summer, issued an order approving Rutland Regional's budget for fiscal year 2025 at an increased net patient revenue of 5%. And it's the difference between 6.1% request and the 5% grant that we're here on today, in part because nothing in the board's ruling explaining why it approved the 5% but rejected the 6.1% really explains how the numbers presented by the hospital add up to that 5%.
Well, is there any rationale for how they reach, excuse me, their target? The target was 3.1,
3.5%.
3.5. You know, it's similar to what we see from the legislature during budget season when they're taking testimony as to what it is that they're going to pass, and it's based upon certain projections that the state's economists make as to what the revenues are going to be to the state over the next fiscal year. So isn't there, I think my question is, isn't there some measure of estimating revenues, estimating costs that go into these calculations to begin with?
Absolutely. And a budget is a prediction. It's a forward-looking dollar amount. So exact precision probably isn't possible. There are a number of factors that the board was statutorily required to consider and did consider. Rutland Regional is not challenging the way the board balanced any of those factors. Its principal objection is that there is no way, reading the board's decision, that you can look at any of the statutory factors and arrive at 5%.
But what you can say is that 5% falls within the parameters on the high and low end.
That's right. That's right.
And is more required?
Yes. The simple answer is yes. We're talking about an ostensibly private entity of the hospital trying to exercise its duty of care to its constituents in proposing what it saw were its needs for cash flow, for expenses and revenue in the upcoming year. It's an ostensibly private entity, but you've got the state coming in and saying, we know you folks at Rutland are competent to run your hospital, but we've got bigger fish to fry. We've got a bigger picture to address. And that's what the board's role is to try to fit each hospital's budget into a larger picture. There's no question about the folks who run Rutland knowing what Rutland needs. And in order to justify the state overriding those decisions, there should be a greater level of specificity and connection between the numbers that were presented and the statutory factors that the board's required to consider.
But
Well-
Mr. Serafin, oh, sorry, Chief
Please,
Justice.
no, please go ahead.
Thank you, thank you. So, but didn't the board find that there were efficiencies that the hospital could have achieved and that had been operating over budget since FY '21?
Yes,
Those are
and
specific.
they specifically, the board justified its decision on the grounds of trying to promote efficiency and the economic operation of the hospital. They also cited the need to shift certain types of care that didn't need to be provided at the hospital to a lower cost, clinically appropriate setting. And the Rutland Regional's complaint is that those justifications don't explain why the hospital's 6.1% request would not have achieved those goals.
Well, they also reference cash on hand, patient accounts receivable.
Positive aspects of the way Rutland is run.
No question that argues in favor of the management of the institution, but these are part of the findings, and if I'm right, I don't think any of the findings of the board are challenged here.
They're not. No. Rutland Regional expects and accepts the fact that this court has long expressed deference to administrative agencies who are tasked with this type of a endeavor. And so it's not a matter of challenging the findings or even challenging the way the board balanced various factors. It's the explanation in the decision that just doesn't seem to add up to 5% as opposed to 6.1%.
In the standard of care, though, we have to look at this as giving deference to the Green Mountain Care Board and presuming that their decisions are correct. So you're arguing the 5% was never articulated, the reason for that. I mean, doesn't the standard of care sort of cover that? I mean, the standard of review.
Right. The bottom line seems to be in the court's precedent on deference is that deference will be provided when an issue is within the expertise of the agency. And none of the arguments that Rutland is raising on appeal really hinge upon the board's exercise of any expertise. In my view, the board's expertise applies to the big picture of how Rutland Regional Medical Center fits into the statewide healthcare system. But as to running Rutland Regional Medical Center, I can't think of anyone who'd be better to defer to than the folks who run Rutland Regional Medical Center. The bottom line is, for this court, I think, to look at a reasonableness standard. Deference is given to the agency in areas of its expertise, which are not really involved here. But ultimately, what the court should be looking for is, was the board's decision reasonable? And if you can't read their decision, and I don't think you can, as tracking the evidence that was before it, the statutory factors it was bound to consider, and 5%, then there's something wrong there. There's the outcome, the bottom line doesn't add up.
But eventually, no matter how much analysis goes on, they have to pick a number. And what are you suggesting that they need to do that makes 5.0% better than 6.1?
Explain it. it just doesn't seem to be there. In the reply brief, we raised the analogy to a compromise verdict. It's like they had to come up with a number. So they thought that what the plaintiff was seeking was too much. So they found a number that was somewhere in the middle and good enough for government work, I guess.
There's a case that actually says that. It's close enough for government. It's a land tax appeal, Killington. Says.
So I should have picked a different idiot.
I
I'd like
don't
to,
necessarily agree with that, but that's what the case says.
I'd like to reserve my time.
Yep, okay.
Thank you.
Thanks very much. Counsel for the appellee, please come on up. Before you start, please introduce yourself and identify your client.
Thank you very much. Good morning, Your Honors, Mr. Chief Justice, and if it may please the court. Ryan Kane on behalf of the Green Mountain Care Board.
Thank you.
The Green Mountain Care Board established Rutland Regional Medical Center's fiscal year 25 budget consistent with the goals and standards set by the legislature. Its legal conclusions are explicitly tied to its factual findings, which, as this court just heard, are not contested. None of the findings of the board are contested by Rutland Regional Medical Center. And the explanation for its decision makes sense.
Well, how did you come up with the 5%? Or how did your client come up with the 5%?
Exactly as the council just described it. They considered the standards established by the legislature, the factors that are required to be considered, looking at the broader picture of administration of healthcare statewide across hospitals and other healthcare providers, and attempted to balance those competing interests, applying those factors to the very specific facts with respect to Rutland. Positive facts with respect to cash on hand and some of the other indicators of financial stability, balanced with facts that are uncontested with respect to opportunities to reduce operational expenses, which have been over budget since 2021, indications of other opportunities based on the Medicare payment to cost ratios being 20 points behind peers is a strong indicator that there are opportunities to reduce expenses. It balanced those factors and determined that Rutland had not justified its request to exceed the benchmark by the amount it did so, but did credit that it was appropriate to be over the benchmark by a certain amount, and chose the number 5%. The suggestion that somehow there's a simple addition or formula that could encapsulate all of these balancing of interests that the Green Mountain Care Board is required by the legislature to do fundamentally misunderstands the role that the board has to play in establishing budgets every year.
How would you define that role?
I think what council indicated, it's looking at the entirety of healthcare administration in Vermont, the unenviable task of that the legislature has given the board of trying to keep costs down while still providing quality access to care throughout the state of Vermont, which has, varied differences between regions, and, administration of healthcare in Chittenden County is going to be very different from Windham County. And yet the board is tasked with ensuring that the overall system is sustainable, that Vermonters receive quality healthcare that they can pay for in the appropriate setting at the appropriate cost.
But doesn't your position give you pretty broad runway to land on here? I mean, the hospital's asking for 6.1. The benchmark was 3.5. I'm listening to you talk, and I'm saying to myself, you're really saying any number in between those two is okay.
Your Honor, that's what the exercise of discretion is. Like I said, if this court agrees that there's no way to simply do this through a mathematical formula, that there has to be some discretion in the decision maker to take factors that are established by the legislature and try to achieve the legislature's goal, looking at this broader picture of the administration of healthcare in Vermont, the legislature has given the board the discretion to establish each hospital's budget. And this court's very familiar with reviewing lower decisions under this abuse of discretion standard. And the standard is not whether this court agrees with the analysis. The standard is not even whether the analysis is so crystal clear that it absolutely follows. This court in Byers held that even an explanation of less than ideal clarity will be upheld so long as the agency's path may be reasonably discerned. And this court, look, when reviewing abuse of discretion, oftentimes it's binary. A trial court or another decision maker could could make polar opposite decisions based on the same set of facts and the same factors and the same analysis. And this court routinely upholds those determinations so long as the decision maker's analysis is tied to the legislative standards and makes some reasonable sense. And I think
Do you think that,
No, go ahead.
do you think that the experience of the Green Mountain Care Board in doing this every year with a number of hospitals might contribute to their decision or their discretion to make this 5% order?
yes, absolutely. I think that's exactly the system that the legislature has developed. They've created this board, which is both has expertise based on the personnel and the requirements to be on the board. There's medical professionals. They're pretty sophisticated group, and they have this experience of establishing each of the 14 hospitals in the state's budget every year. So they're able to see, and they brought in expert testimony of regional trends as well. There was a very substantial record for the factual considerations for why the board made these findings. And they're all set forth in the board's decision. There isn't, like the board recognized that there's an affordability crisis in Vermont right now. They recognize.
Isn't there also an access crisis in Vermont? Access to specialists?
That certainly is a possibility. I'm not sure that that's specifically borne out in the facts of the record of this case, but that's certainly a big concern. But the board recognized that hospitals play an oversized role in the administration of healthcare in Vermont compared to other states. And so there may very well be a need for access to additional services, but the legislature has said that the board must ensure that Vermonters get that quality care at the appropriate setting and for the appropriate cost. And so the boards recognize this trend of the prices keep going up. Vermont in the 90s was very low in healthcare spending compared to other states. And now we're routinely one of the highest. And the oversized role that hospitals play in that is something that the board and its expertise has recognized. And all of Rutland's arguments with respect to why it needs to have the 6.1 that it requests go to that question of utilization. We want more people to come to Rutland to get more services. And they said, yeah, Rutland has Rutland's interests in mind. They know how to run Rutland Hospital. They know how to try to provide as much quality care as they can to people from Rutland County or anywhere else in the state who might travel there.
Can I turn you to another issue? Yeah, the question of integrating the FY23 overage or whatever it's called.
Certainly.
Into the FY25 budget order. And I think if I understand it correctly, the appellant is arguing that contested case principles should apply to that. There's a lawsuit that's pending, am I right, in
Yes.
Rutland Superior Court, in the civil court, about this right now as we speak?
We
Is
had
that
oral argument in that matter last Monday, a week ago.
last Monday.
So yes, that
So-
exact question is pending in Rutland Superior
Is
Court.
anybody arguing here that we should not decide this issue before that decision is made?
This court has already recognized that it lacks jurisdiction to answer that question with respect to the validity of the fiscal year 23 enforcement action.
Well, what
Rutland,
about the application of the FY23 overage to FY25 budget order?
that's acknowledged in a footnote in the budget order, which approved their requested increase in commercial rate cap, which isn't a setting the rate, it sets the cap, but it said is accepted what they requested, the 2.8%, and then said this other order, which is a final binding order of the board, requires a reduction of that to account for the $11 million in excess revenue from fiscal year 23. So the board, whether you consider it incorporated in or not, it's a separate final order of the board that has the effect of reducing the approved rate from the fiscal year
But
25
that
budget.
separate or final order of the board is being contested right now.
It is, but it was not requested. Nobody requested a stay of that order, and they're arguing the validity of it in Rutland Court presently. This court, Rutland attempted to appeal that directly to this court, and this court, I think, correctly concluded it lacked jurisdiction. So the opportunity to somehow, like any other final order of an administrative board or a trial court.
So the issue that's ripe for us on this is what? Articulate that for me.
With respect to the fiscal year 23 budget?
Yeah.
There is none. There is none.
What about the application of the overage to the FY 25 order? Is that issue ripe with us?
No, because all that is again, it's acknowledged in a footnote that the fiscal year 23 enforcement order requires a reduction in their commercial rate caps for the next 2 budget years. Whether it was called out in the decision or not, I don't think changes anything, because it says the board's clear, we're approving your commercial rate increase at 2.8%. The board then acknowledges in a footnote, this other order requires that be reduced for each of the next 2 years. The validity of, as I said, that there was no stay of the fiscal year 23
Yeah,
enforcement order.
Right.
That has the effect, whether it's in this board decision or not, of reducing the approved fiscal year 25 commercial rate increase by the appropriate percentage from, I don't remember the
Okay,
exact
what do you
number.
say about the merger, the other issue they appeal? I'm sorry.
No, Chief.
Huh?
No. Mr. Chief Justice, please. When you're,
The third-
I'm along the same line of questioning as you, but
Okay.
I just want to strip whenever you're done.
Okay. I just have one more. The third issue, as I understand it, is entering in a decision that combines both of, it's simultaneous as to both the commercial rate to the insurance carrier and the patient, I can't remember the acronym.
Net patient revenue.
Yeah, that's it.
The effect of the two of those as reducing access to care.
Yeah, what's your position on that?
That nothing in that I think that's Rutland's characterization of the effect of the budget order, but nothing that they don't contest any of the factual findings that the board used to make independent determinations with respect to each of those factors. So the confidential supplemental information that they provided, which I think goes to that, that's what they point to as demonstrating a reduction in access to care, doesn't address any of the factual findings of the board. It says, and I mean, I think I'm not going to get into any of the confidential stuff, but the actual quote, and it's there's a supplemental printed case or a confidential printed case. What they actually said was that the combination of those two things would force Rutland to consider difficult changes in certain programs, and then outlines those changes. So they're essentially saying we may have to reduce utilization in some areas as a result of this, but in fact, that's not contradicted by the board's decision in any way. And that access to care is just one of the factors that the board has to consider, both for Rutland and for the entire statewide administration. So I don't think that that's actually really an issue that's before the court, because that's just Rutland trying to substitute its judgment about which of the factors the board should weigh in making the legislatively mandated requirement to establish the hospital's budget each year.
So, Mr. Kane,
No,
this
can
is-
I just?
Go.
I was just
You
gonna
go.
ask this next question. May I, Justice Cohen, please?
you may, absolutely.
I enjoy really amusing Justice Carol here as she watches the most junior justice try to ask a question. So just let me get the question. I'm just going to switch, and then I just want to hear, tell me why the APA does not apply.
To the contested case proceedings?
Yes.
Again, that question is not before the court, but the APA, the enforcement of the fiscal year 23 budget violation, the deviation from their budget, they took an $11 million. The way that the board tried to remedy that, and there are options, the board can assess penalties for violations of budgets. It can do other things like seek emergency relief in court. But one of the options it has is to take corrective action to remedy those budget violations through the budgeting process. And the considerations, the factors for how to remedy that are the same as the factors that we've been discussing in establishing the budget.
Under 9456?
Yeah, exactly.
Okay.
It's all governed by 9371 and these broad principles. So the nature of that enforcement proceeding, because it is just focused on corrective action, is the same as the nature of these other proceedings, which are, I think, as counsel characterized it, this isn't just about Rutland, it's about the broader picture. And that broader picture is not subject to a contested case, two-party proceeding, because it's more about public policy. And so, but maybe you'll have a chance to review on that after the Rutland Superior Court
I
does
want to
its
thank
work.
Justice Cohen. Thank you, Justice Cohen.
So, Mr. Kane, this is a community hospital. It's got significant competition to the north by the University of Vermont Medical Center. It's got significant competition to the east by Dartmouth Hitchcock. It needs to stay relevant. It needs to stay competitive. And part of that being competitive is spending exorbitant amounts of money on technology, equipment, specialists, and the like. And so aren't we prohibiting it from doing its community service to Rutland by limiting its budget requests?
No, Your Honor, I don't think so. That that difficult decision is one that the legislature has tasked the board with making. And if it were simply up to Rutland to decide the level of services it could provide, then it's just going to continue to increase utilization of Rutland because that's what they believe to be in the best interests of Rutland and their community, but that may be contrary to the best interests of making sure of addressing the affordability crisis of healthcare that Vermont is facing. So the board, and again, I think the positive facts that have been discussed with respect to Rutland, cash on hand, the stability, the board wouldn't have decreased this and said, we're going to lower your revenue if Rutland were like Blue Cross Blue Shield on the potential insolvency. The board said, you're very strong, stable economically, yet there are opportunities for efficiency. There's opportunities to reduce expenses, and increased utilization is not sufficient to justify a 6.1% in net patient revenue increase. So the board considered those types of factors in its decision, which is, I think, again, we're well past the low level of, does it make some level of reasonable sense? Is it good enough for government work, which is the legal standard here? And so for all those reasons, I'd ask this court to affirm the decision of the board.
Thank you very much. How much time does the appellant have, please?
Appellant has 5 minutes and 32 seconds remaining.
Counsel? You withdrawing that second issue?
Pardon?
Do you withdraw that second issue?
No. The
So
reissue-
how is it live? Explain that to me.
No, just to be clear, are we talking about the Administrative Procedure Act or the?
Well, I'm talking about the integration of the FY23 overage into the order for the FY25 budget.
Okay, that actually is what I'd like to address in my remaining time.
Yeah.
It's important to focus on a specific subsection of Section 9456. Section 9456 D1 stands for the proposition that the board's fiscal year 2025 budget order is what controls. So the board cannot enforce the fiscal year 2023 budget order by implementing a remedy in fiscal year 2025 unless that remedy is included in the fiscal year 2025 budget order, and it is. Attorney Kane refers to it as in a footnote, I believe it's footnote 27 in the board's order, but it's in there. So the question of whether the Administrative Procedure Act applies addresses how the board went about enforcing the fiscal year 2023 budget order. We presented the argument in the brief that the terminology of Section 9456H dealing with enforcement is sufficient to trigger the requirements of the contested case provisions of the Administrative Procedure Act, and therefore the board should have provided those procedures, but instead it was a totally integrated process. The enforcement process was integrated with the process of establishing hospitals, all of them, fiscal year 2025 budget orders.
Was there an objection to the procedure below?
Yes, yes. The Rutland Regional objected on several occasions to the lack of contested case procedures. Now, as to the court's jurisdiction, the Rutland Regional did try to appeal the fiscal year 2023 budget order to this court, and this court dismissed that, saying that the exclusive remedy for the hospital was in the Superior Court. That is pending. Jurisdiction can be a fluid thing. In the hospital's reply brief in footnote 5, we noted that there's a bill pending in the legislature, Senate Bill 63, that at the time of the briefing would have clarified that contested case provisions don't apply. But it took away, at the time, a provision that would have stripped the Superior Court of jurisdiction. As that has now passed the House, but the House has proposed to put that jurisdiction stripping language back into the bill. So over in the legislature, they're deciding whether Judge Burke down in Rutland is either going to have jurisdiction to decide the Administrative Procedure Act issue, or whether they're going to say in the end that's for this court to decide. So it's by the time the court gets around to issuing its ruling, the legislature may have spoken differently. the points that we made in the brief establish why the Administrative Procedure Act applied to the fiscal year 2023 enforcement decision, and why in establishing the fiscal year 2025 budget order, it was necessarily incorporating the remedy for Rutland's overspending or over revenue it got incorporated into the 2025 order.
What do you say about, you go right ahead. You go right ahead.
Thank you,
Not your
Justice
day,
Carroll. Thank you, Justice Carroll.
Take all the time you need.
They're so kind. So, Mr. Serapia, let me just follow up on something you just argued regarding the APA. If there was no stay, correct, of the FY '23 enforcement order.
Correct.
So if there's no stay, it's valid and binding. So I guess I'm a little confused as to how the APA then would apply.
Well, the argument is that the procedure followed in developing the 2023 enforcement order was invalid, and it needs to be reconsidered with all the procedural protections of litigation that is provided through a contested case. It wasn't done that way. It was done much more informally. But the statutes comparing 9456H and the provisions of the Administrative Procedure Act compelled a more formal procedure.
You know, the only thing that H refers to is violations, right? It's that is the word that's in H, and there's another section in that statute. It's B4 that specifically refers to employing H for resolution of violations. Is this a violation that we're talking about here?
I believe it was the word was deviation. There was a deviation from the approved fiscal year 2023 budget.
Chief,
Okay.
can I ask just one?
Yo, please. Oh, how about it? Yeah.
Is there anything in the Green Mountain Care Board procedures or anything in the statutes that if in the Superior Court that decision made below was reversed, does the Green Mountain Care Board have any remedies to address that in future establishments of budgets? In other words, if they said that was wrongly decided below, can they compensate Rutland Regional Medical Center for that in future budget dates?
I believe that the rule that the board invoked, 3.401, well, we're calling it 3.401D, allows the board to effectuate whatever remedy it comes up with in future budget years.
Okay, thank
And
you.
that's how we got here.
Thank you.
Thank you.
Thank you very much. Please call a conclusion of the hearing.
The next hearing for the court is scheduled for 10:45 this morning.